Good morning. Please be seated. This is the time set for argument in J.P. Morgan Chase Bank versus MGM4 LLP et al. Our civil number 13-0145. We have read the briefs. We're familiar with the record. We think we understand the issues. So keep that in mind as you make your arguments here today. We're very interested in what you all have to say. Each side will have 20 minutes within which to present their arguments here today. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your time in that regard. As you approach the podium, please identify yourself and your clients for us. We are recording these proceedings, both by audio and by video. And the video portion of the arguments may be accessed eventually through YouTube. So just make a note of that. With those housekeeping matters, the appellant may proceed.
Thank you, Your Honor. May it please the Court, I'm Darrell Manhart, and I'm here representing Appellant MGM. Sitting at the table today is Dave Shine, who represents Appellant LVIH. He has yielded all of his time to me, so I'll be making the arguments for Appellant. I'd like to reserve 3 minutes of my time for rebuttal. This is an equity case to resolve the competing priorities between two deeds of trust. My client, MGM, is just an entity that Gary Schuster, who's here today as well, and his wife formed to pool family money together to try to buy a house in their old neighborhood. He went to a public auction sale, a trustee sale, where what was shown was a first priority interest being sold. He paid $1 million cash. Yes, Your Honor.
Chase suggests that that Mr. Schuster and his entity, MGM, stand in the position of Ms. Popple relative to claims, defenses, notice, all of that. What do you have to say about that?
Well, Your Honor, the stand in the shoes argument is what they convinced Judge Cooper to rely upon, and as a result, Judge Cooper looked only at the equities vis-a-vis Chase and Popple, and no case was put on regarding MGM, and no findings were made. And the reason that stand in the shoes argument's invalid, I have about two approaches to take to that. One is what do you think of when you say A sells to B, B takes the interest that A had, B stands in the shoes of A. That's really what their premise is. But what you have here is a sale that occurred in July 2007, where there was a sale from Popple to Barry Dane. Barry Dane held title. Barry Dane gave a deed of trust to WAMU. Barry Dane gave a trust to Popple. And then there was a trustee sale by Chase of the WAMU deed of trust. So did Chase stand in the shoes of Barry Dane? That's the predecessor in title. The same with MGM. It bought at a trustee sale. The predecessor in title is either Barry Dane or it's Chase, which had foreclosed on that interest. That's because stand in the shoes is a notion that's associated with privity. There's no privity here between MGM and Popple. So the stand in the shoes test is verbal sleight of hand to deflect attention away from what are the equities. The equities test is between Chase and MGM. MGM was a party sued here. There was an earlier suit against LVIH, and there's a separate suit against MGM. They're consolidated. So stand in the shoes is invalid. And the other part that I said I want to point out to show why that's invalid is look at the test that a court of equity applies in deciding whether to bail out a party like Chase when it finds itself on the record having a subordinate position to what the public record shows. And that test is a court looks at, even if there's some other fairness reason why you might elevate that priority, the ultimate question at the end is, does it prejudice an intervening interest? Now, an intervening interest is always someone who came after the two parties that are vying for priority in those claims. If you say that the successor, the intervening interest, stands in the shoes of a predecessor, that test evaporates. It's illusory. There's no intervening interest test then, because all you're doing is looking at whether the two priority claims, if one prevails over the other, then you're saying everybody else stands in the shoes.
So your point is the equities, whatever those considerations may be as it relates to either Ms. Popple or Mr. Berrydane, have nothing to do with this dispute.
That's correct, Your Honor, as dispute between Chase and my client, MGM. And my client, MGM, had a trustee's deed from a sale before this case ever went to trial. So what you have is two prior deed of trust sales with no change from what's shown by the public record.
Well, I'm suspecting that we're going to hear from Chase that they believe that the Popple deed of trust was extinguished in 2008.
They do claim that, Your Honor, but they claim that based upon the presumption that they have already established their interest as prior. So I'd like to talk, if I can, about the purpose of the the purpose of the real property recording system. We have a real property recording system that's supposed to govern. The presumption is that the real property record documents are correct, absent proof of something to the contrary. And all the statutes talk about proving actual notice to another party or a subsequent purchaser. And that's sort of like trench warfare, Your Honor. You have to prove it for every party. You don't prove as between Chase or WAMU and Popple that she had notice, and then that follows with everybody else. That's the stand in the shoes argument. You have to show that a party that is relied upon the public record had notice to the contrary, and they didn't prove that. And the real property recording system is there for parties to rely upon that. And if you pardon me while I look down at my notes, I want to read a quote from a case 100 years ago, Newman versus Fidelity. The Arizona Supreme Court said that an interested party, quoting, has the right to presume that public records speak the truth and to act thereon in all matters affected by instruments required by law to be recorded. These documents, deeds of trust and deeds, are required to be recorded. The Newman opinion goes on to state, quoting again, if the law requires or provides for the recording of certain instruments and they are not recorded, a party searching the records is justified in concluding that no such instrument exists and the law bears him out in that presumption. So when Mr. Schuster, that's MGM, when he goes to this trustee sale, his testimony is he'd looked at the real property records ahead of time and he found nothing prior to the lien that was being sold. And he looked at the trustee sale guarantee, the title report that the trustee had there at the sale, and it showed the same thing. He was entitled to rely upon that record. And if I can read from
what effect, if any, is there to the allegation or perhaps uncontested facts that at that sale certain legal representatives from Chase appeared and voiced their objections and theoretically put Mr. Schuster or MGM on notice that there was a problem?
Well, Your Honor, I think there's supposed to be a power of threes, and I seem to always have like two comebacks, but I have at least two responses on that. One of them is, Your Honor's focused on something that is not in the record for purposes of proving Chase's case against MGM. They did not call Mr. Schuster as a witness in their case, and when he was called in the case for the defense, they did not even cross-examine him. You're focused on something that comes up in the offer of proof portion, and that's only in this record for purposes of deciding whether the BFP issue was improperly excluded or not. Now, having said that, if you want to focus on that too, I'll focus on that anyway, it's my second part, which is Chase sent two representatives there, and all the record shows is they made a ruckus outside where the sale was about to start in like the hallway or something, and that Mr. Schuster was aware of that. Now, the only inquiry notice that a person has is that of a reasonable and prudent person under the circumstances. The circumstances is that the trustee sale is about to start. He hears something out there. There's no evidence that they said, we're here for Chase, and Chase claims it has prior interest. He just heard a disturbance, and he could tell there was something going on. When the trustee comes in, and by the way, those people did not stay and participate in the sale. They just made some objecting sounds out there. Mr. Schuster asked the trustee, what was that all about? And he says, well, they have an objection to the sale, but they went before a judge, and the judge refused to stop the sale. He looked at the title report, the trustee sale guarantee. It showed no interest prior. That is all the inquiry notice you can expect of a reasonable, prudent person when the sale's about to start. There's nothing else he could have done. And I'd like to further point out that what Chase did then is tantamount to a contempt of court. They had been in front of Judge Mangum and asked Judge Mangum to stop that sale, and he said no. They didn't ask him for a stay and then file a special action or file for an accelerated appeal or run up to this court and say we want to stay. They left the courtroom with no stay. They showed up and they're trying to stop the sale indirectly in violation basically of Judge Mangum refusing to stop it by making a ruckus outside. They can't use that to then say that creates the same constructive notice as if we had stopped the sale or filed a lis pendens and had it recorded. So that's ineffective. And I guess I do have a third point. If you look at BT Capital, even a lis pendens doesn't help you there. BT Capital says a lis pendens doesn't protect you against reading 33811C and E together, which says if you don't stop that sale by 5 p.m. the day before, you're out of luck. You don't have a claim anymore. So I'm getting sort of off of the sequence I was intending, but if you go backwards now in time, what Chase should have done was they should have filed their action back in 2008.
Well, if we look at 811E, assuming you're right and your client ends up with the property, did they take the property subject to a lien by Chase? If you read the last sentence in E, if you've looked at that at all, but it seems to suggest that the conveyance would be absolute, but subject to all liens, claims, or interests that have a priority senior to the deed of trust. So I'm wondering if you've thought about that, whether Chase, as an alternative argument here, has a lien, even though your client ends up with the property.
Well, they don't, Your Honor, and I'm sorry if the brief fails to adequately discuss that, but it is discussed in the brief. 33811E talks in the present tense about having that claim, that interest. It doesn't talk about having an argument for one. And as of, I'm thinking of the dates in my head, of October 2008, Chase had already foreclosed on a deed of trust and acquiesced to its second position, and it no longer even had a claim to make. It had been extinguished by merger at that point. But even if you take it up to now February 2009, when the LVIH is having the sale on the Popple deed of trust, all they have is an unadjudicated argument that they were entitled to priority. They've had a trustee sale that I've just said has wiped out their claim, but even if you ignore that, they had an unadjudicated claim. And that's what BT Capital says too. It reads paragraph C and E together, so you have to harmonize those two. And they say that if you have a claim, an unadjudicated claim, you have to have it adjudicated or you have to stop that sale because you lose it. And if you look at BT Capital again, the same interest that Chase is trying to argue that we were at really prior all along, that's what BT argued. It says we were the purchaser at a trustee sale before, I'm going to forget what their party name is, PCS or something, which PCS was the purchaser. So our claim is really prior in seniority. And this court in BT Capital said that's not enough. You can't just have an argument, an unadjudicated argument that you have priority. You have to stop that sale, because if you're waiting till after the sale to try to adjudicate your argument, it's too late. It's already been adjudicated by having the trustee sale go forward. And if I go back again...
I was going to say, would your argument then be the same if Chase had hypothetically sought a special action and the panel went before decided not to grant a stay and dismiss the special action or deny relief?
Yes, Your Honor.
Okay. So you can do everything, but unless something happens, you're in the BT Capital world.
That's right, Your Honor. Okay. Because what Chase should have done, sorry, I think I started this and didn't get it out. What Chase should have done back in October 2008, I'm sorry, prior to October 2008, sometime in 2008, is it should have filed a lawsuit in court to establish its priority then. It should have filed a notice of lis pendens then. And if you look also at comment F to restatement section 7.6, see if I can turn to that quick enough, that even says that. It's laid out in the test for the restatement. talks about what a payor party should do. The comment tells the payor party, that's the one in the position of Chase, that the payor, I'm quoting, the payor could, of course, forestall this problem by an immediate assertion of subrogation and the filing of an appropriate action to establish priority. The filing of such an action, and in some jurisdictions, the recordation of an appropriate notice of lis pendens, would give constructive notice of the subrogation claim to anyone contemplating purchase of a junior interest. So they didn't do that. And the consequences of that are you create a delay by their conduct in not bringing that claim that allows both them to change the public record by conducting a sale that then causes their prior lien to disappear from the record in the sense that a title report will no longer show it, and another interest to come on, which is another trustee sale notice. And that's discussed in comment F2 is about what the effect on that on an intervening interest. It talks about delay.
Counsel, I think you're reading BT Capital too broadly. That case, when it construes 33811C and E, is talking about sales, trustees' sales. It's not talking about sorting out priority. And when you look at that last sentence of E, if a court determines that there may be a senior lien, that's an issue that's left after the sale. Those cases, BT Capital, Madison, they all deal with the ability of a trustee or a beneficiary under a deed of trust to actually go forward with the sale and compel the sale. It's not talking about resolving priorities of liens.
Well, Your Honor, I think it's consistent with that, though, and it does show the court reading C and E together.
Right, but you're reading C in light of E, and I think BT Capital read C and also helped construe it with E. C deals with a sale, a trustee's sale, and E is also consistent with that. So I'm not sure how you get to this holding of BT Capital about if you have any objections regarding priority of your lien, you waive that as well. I mean, BT Capital, Madison, all those cases kind of deal with the wrongful foreclosure situation, a party that is claiming that the beneficiary or the trustee doesn't have true title or doesn't have a true right to go forward with the sale. And so under these statutes, you have to stop that sale and you have to litigate a party's standing to go forward with the trustee's sale. You can't let the trustee's sale go forward and then after the fact say, wait a minute, unwind the sale. That's what those cases talk about. Well, that's not our situation here necessarily. Here we're talking about who has priority, who has a claim and junior and senior liens on the property.
Well, Your Honor, that may be a fair reading of BT Capital, but BT Capital, even if it's narrowed to your distinction right there, doesn't help Chase any here. And the part I'd like to read just from a little bit more of the comment after the restatement does, I think, address what you're talking about, is what they should have done. It talks about what happens when you delay, as Chase did, letting the record go forward without them establishing that interest. And in comment F says, goes on to refer to the subsequent purchaser, that would be MGM in this case, believing, again quoting, I'm sorry, I wanted to start out further. The comment talks about a delay by the payor in recording his or her new mortgage, or a delay in otherwise publicly asserting subrogation to the mortgage paid. Those are given as the examples, and what it says is that the subsequent purchaser, quoting, from the appearance of the public records that he or she is acquiring a first lien, is entitled to rely upon that. So you don't trump the public record by looking at them saying, well, we had a claim. They didn't get that claim adjudicated. They allowed the public record to still show the WAMU deed of trust was in second, and then it disappears after their sale. The public record shows the Popple deed of trust was recorded first and remains first according to that public record. In fact, it's the only lien shown on the public record by the time that sale happens. I'd like to save the rest of my time, if I may, for rebuttal.
Thank you, counsel.
Tim Thomason, Your Honors, for J.P. Morgan Chase. The fundamental, I would say, mistake in MGM's approach throughout this case, and before MGM, Ms. Popple and her entity, is the notion, according to them, that if you're recorded first, you are first. It permeates this proceeding. In fact, Ms. Popple's lawyer, who wrote a letter back before Chase's foreclosure sale said that. Well, we recorded first. And so they consistently say, we're recorded first, and all you have, Chase, is an unadjudicated claim. Well, Your Honors, that's not the law in this state. It takes me back to my law school real property class, where I learned that there were 3 types of recording statutes throughout the country. There's pure race, there's pure notice, and there's race notice. And MGM acts like Arizona is a pure race state, a pure race to the recorder's office, and if you record first, you're first. But we're not. We're a race notice state. As ARS Section 33412B states, unrecorded instruments as to all subsequent purchasers with notice thereof shall be valid and binding. And so the Chase deed of trust, which was signed and granted prior to Popple's deed of trust, is valid and binding as to anybody, specifically Ms. Popple, who has notice thereof. Which takes us to the...
Not really a subsequent purchaser, though, is she?
She is, Your Honor, because as far as the deeds of trust are concerned, I mean, she had a prior interest too, certainly. But the deeds of trust were signed, the Chase deed of trust is on July 19th, and her deed of trust is signed on July 26th. So she did get her deed of trust later. She is a subsequent purchaser, and she was on notice of the Chase lien, and that takes us to the factual findings the trial court made, which were adequately supported by the record that Ms. Popple was on notice. You almost have to just look at common sense when you think about that situation, that a multi-million-dollar property, Ms. Popple knew money was being loaned. She signed all kinds of documents demonstrating that she knew there was going to be a loan, including an affidavit of real property value. The trial court's factual findings, although briefly addressed in the brief, I don't think are really a serious issue on this appeal. If we take those findings, which were supported by the record, then Chase is and had at all times a first position deed of trust. And it is no different, absolutely no different than if we recorded first, because first is first. And the statutes in this state make no distinction between whether or not you're first because you were recorded first or or first because the other person was on notice of your position.
So what you're saying is that if you buy a title report, you've got to go beyond that and look to determine whether or not the second position was signed before the first position, in order to determine what the priorities.
Yes, with certainty, Your Honor. The answer to that is absolutely yes. The title reports only provide so much information. They provide what's of record, but a title report doesn't determine and doesn't adjudicate priority. And the notice issue in that, although maybe not addressed by a title report, is in fact the law in the state. Which then takes us to, I think, the MGM's position that somehow this priority, that Chase is first, as the trial court found, that somehow that priority was flipped by their own trustee sale. First point on that. MGM takes the position that a purchaser at a trustee sale, who is not a bona fide purchaser, which I'll address in a minute, but a purchaser at a trustee sale obtains some super interest or obtains some priority. That's not the law. There is nothing in the trustee sale statutes that provides a purchaser at a trustee sale who is not a bona fide purchaser without notice with some type of special status. In fact, it's just to the contrary. Your Honors, it is well known and well established that when you purchase at a trustee sale, that is a risky proposition. The statute provides, 33811E, provides what you get at a trustee sale. The trustee's deed operates to convey to the purchaser the title, interest, and claim of the trustee, the trustor, the beneficiary, and their respective successors in interest. So MGM, by buying at the sale, did exactly what we have said. They stepped into the shoes of the trustor, Barry Dane, who is clearly the bad guy, and the beneficiary, who was Ms. Popple, who I would submit was also a bad guy, who implicated herself in a fraudulent scheme and knew of the WAMU deed of trust. So under the statute, MGM absolutely, when they bought at that sale, stepped into Ms. Popple's shoes. They obtained no priority, and they obtained absolutely no protection. For purposes of argument, they are the same. When they purchased at that sale, they are in the exact same position as Ms. Popple, and there is nothing that they will provide to you in the trustee sale statute to the contrary. The second argument, though, that they make in arguing that somehow Chase's priority, first position priority, was flipped by their trustee sales, BT Capital. The first and foremost on BT Capital, trustee sales do not and cannot determine lien priority. They don't. There's not a mechanism for doing that in the trustee sales statutes. And that's what MGM is really contending and telling you, that that trustee sale somehow determined priority. But their entire position begs the question, Your Honors. It begs the question of who is in fact first, and goes back to their fundamental flaw, their fundamental misperception that recording grants them some priority as a matter of law. That's not true. BT Capital was based upon, as I think Judge Gould pointed out, two parts of ARS Section 33811. C, which provides that all defenses and objections to the sale are waived if an injunction is not obtained beforehand, and then when a trustee's deed is issued, if the interest in question is extinguished by that deed, which kind of goes to the beg the question part I was talking about. Under 33811E, the conveyance is absolute, but it is subject to all interests that have a priority senior to the deed of trust. So, in BT Capital, two things were present that are not present here. The party there had an objection to the sale, contending that BT Capital argued that it had already purchased at a prior trustee sale. There were three sales. One, there was a procedural flaw in. There was a second one that BT Capital ostensibly purchased at. And then the third one. So BT Capital had an objection to the sale, but I think more importantly, the interest of BT Capital when that trustee's deed was issued at this third sale, that interest of BT Capital was extinguished because BT Capital, their only interest and their only claim was when they tried to purchase at that second trustee sale. That interest was clearly subordinate to the foreclosing deed of trust. In our case, neither of those situations are present. Chase did not have a defense or objection to the sale. It had a prior interest in the property that it claimed and claims was unaffected by the sale. And second, its interest under 33811E was not extinguished by that sale because we had a prior interest in that property as had been determined by the trial court.
So MGM would essentially buy the property after looking at the title report, subject to whatever fight was coming.
Absolutely. Yes, Your Honor. It looked like you were formulating another question, so that's why I was hesitating. Okay. Yes. And that is exactly the situation here, that they, just as Ms. Popple, as I said before, they stepped into her shoes. Whatever situation she was in, they were in, and they had no additional protection whatsoever. Now, I said previously that unless they're a BFP, you could, theoretically, in any real estate transaction, be a bona fide purchaser at value and then obtain some protection. I want to say two things on that. First of all, the trial court, in its discretion, ruled that MGM had not asserted that defense, and they had not. Bona fide purchaser is an affirmative defense that must be pled. It was never pled in this case, and it was never argued by MGM in any of the multiple motions that were brought before the trial court. Had in fact that defense been pled and asserted, there would have been additional discovery. There would have been all these people that were at the trustee sale would have been talked to about what was actually said. But, Your Honors, the second point, and let me finish with this, though, on that point. Obviously, when you're talking about a disclosure issue or discovery issue, this court gives extreme deference to the trial court. Judge Cooper was in the best position to determine if that issue had been raised and if it had been pled and if there would be prejudice as a result of that. Her decision was adequately supported by the record and, in fact, was true. However, I think that in looking at the situation, and this court looking at whether or not what she did was correct, can also consider what she considered at the time, and that was Mr. Schuster's testimony outside the presence of the jury as to what happened. And I would submit, Your Honors, that the record that we do have demonstrates exactly why MGM never asserted that defense, never asserted it throughout the case, and it seemed evident to us why they weren't asserting it. It's because they could never establish that they were a bona fide purchaser. Mr. Schuster went to the sale, and he admitted on his own testimony, representatives of Chase were there, they had asserted there was a problem with the sale, and so he knew there were issues with that, but he didn't care because he had a commitment to get title insurance. So he didn't care what all this was, but he was clearly on inquiry notice that there was an issue here. At the end of the day, what you have here is a situation, a lien priority dispute, where Ms. Popples clearly took subject, as the trial court found, and was unaware of the WAMU deed of trust. When it comes down to, was there anything about the trustee's sale that MGM did or Ms. Popple did that changed those priorities? And there simply wasn't. Whoever bought at that sale took subject to whatever liens were senior. And the Chase lien was, in fact, senior. Didn't have to be recorded first, but based upon the trial court's findings, Ms. Popple took subject to that, and she was aware of that. So unless the... Go ahead.
Thomason, so is your primary position then is that the WAMU Chase lien is senior because of the notice argument, or is it senior because of equitable subrogation?
For purposes of this appeal, Your Honor, I mean, we obviously argued both throughout the case. For purposes of this appeal, our primary argument is the notice issue. We don't have to get to equitable subrogation because of the fact that Ms. Popple, under the recording statute, was on notice and took subject to our deed of trust. And so that is certainly our primary position on appeal, is the notice issue, Judge. So unless the court has any other questions, those are the points that I wanted to make.
Thank you,
Okay, thank you.
Mr. Manhart.
Thank you, Your Honor. Well, Mr. Thomason just basically said that they're claiming an automatic priority. He's saying that a party can grant itself equitable relief, that they were always in first, even though the public record shows the contrary. That's not the law. They don't get to grant themselves automatic equitable relief. And if I can go back to merger again, you had them having what they say was a preserved lien claim, priority claim. And let me accept that premise briefly. Let's say they had that, but they went to sale in October 2008. And I cited at least two cases in our brief that says what happens, that is, you exchange your lien claim for a title interest. So they gave that up before we ever get to the February 2009 sale. They had a lien priority claim that they then traded for title when they foreclosed on their own deed of trust. So it didn't exist after that. It was extinguished by the doctrine of merger. They've artfully tried to claim here that somehow we're flipping the priority argument around. There's no priority determinations based upon the dates on the documents. It's the dates they're recorded. If you've had any experience with real property records, you know people sign things at all sorts of times, and then the escrow officer makes the exchange when it's supposed to close. So the fact that they can point you to the date on a document is really irrelevant here. It's the date it's recorded. And these are recorded in the order of Popple deed of trust first, Chase or WAMU deed of trust second. And their argument, too, is that a party can't even rely upon the real property record. They're saying that if you look at the record, you have to go beyond it. You have to look at the documents themselves and go back, make inquiries of people. Like, I noticed this one date's signed before the other one, even though they're recorded differently. That's not what the case law says. The case law says a presumption that you're entitled to rely on that public record. In fact, the 87-year-old case I cite, the Phoenix Title versus Old Dominion, talks about hidden equities, that the purpose of the recording system is to protect people from having to have hidden equities sprung upon them. That's what this is, a hidden equity that they're claiming that you could look at the document and it shows Popple deed of trust first, WAMU deed of trust second, but really we were always first. And you would have found that out if you had asked us. Parties don't have an obligation to go back and interview everybody in the chain of title. I'm sorry, I see I'm out of time. Thank you.
counsel. We appreciate the presentation of the case, both in the written briefs and an oral argument here this morning. We're going to take this matter under advisement. We will issue a written decision in due course. And with that, we are adjourned.
Good to meet you. I'm sure we'll cross paths.
Hi, Daryl, Ann Tiffin.
Hi, Ann.
Nice to
Oh, we
meet
have some stuff together now.
Right, yeah.
Nice to meet you too.
Yeah.
You do realize that when you talk to your client, or your person paying for your client, if you did, we're out of business. Because we can't go on the road. You can't.
I got to argue my case.
I know, I'm just saying. I think the public policy, they will uphold how that I think.
See ya. Take care.
Mr. Schuster. Hi, how you doing, Mr. Schuster? How are you? So what's the word?
More of the same. We just moved offices.
Yeah, I still have a couple of lingering things going on with my group. I got